Well, good morning, everybody. It is delightful to see so many familiar faces, but also so many new faces here at our new venue here at Monash College. My name's Melissa Castan. I'm a professor of law in the Faculty of Law at Monash University, and I'm the outgoing director of the Castan Centre for Human Rights Law, and it's my deep pleasure to welcome you here this morning. I want to begin by acknowledging the Wurundjeri Woiwurrung and the Bunurong people of the Kulin Nation on whose lands we meet today, and pay respects to elders past and present, and extend that acknowledgement and welcome to all First Peoples here this morning. A special welcome to National Commissioner Sue-Ann Hunter, Co-Chair Meriki Onus and Principal Lawyer Kari Walker, who join us today. And we also have representatives here from Gulangwal and from the Victorian Government Treaty Unit and many other workplaces. So a warm welcome to you all. As we meet today, we acknowledge that the law and its ramifications still continue to play such a significant role in the lives of First Peoples. And I feel that it is still our obligation as practitioners and students and knowledge holders of the law to recognise the ongoing role and the impacts of Captain Cook's law, the Anglo-Australian law, on all First Peoples across Australia. And I, once again, as I mentioned last year, want to point out that there have been ongoing attempts to undermine and negate the importance of welcomes and acknowledgements, and these are proper protocols. And in my view, these are an important aspect of restoring proper legal relations within our law and political domains. They are at least a bare minimum. I want to also acknowledge that we just observed NAIDOC Week, and that was held nationally in early July. In case you missed it, it was 50 years of decade. It's the excellence and the cultural and Torres Strait Islander communities over 5 decades of the NAIDOC movement. And these acknowledgements are particularly important given that here in Victoria we are the first Australian state to have a treaty and a statewide treaty act. I'm very glad that we are able to recommit to the treaty processes here at Monash, and we are working on the implementation of the recommendations of the Yoorrook Justice Commission, and this is work that we are all invited and authorised to do, and I urge you to join in on doing this work. I'm so glad that all of you are here today for this annual conference. The conference, as well as being a day of conversation and discussion about issues, marks the formal handover of my directorship to our new director, Associate Professor Ronley Sifris. And we'll hear a little bit more about Ronley soon. Thank you, Cheer Squad. We'll hear a bit more about Ronley in a minute, but I did want to say how pleased and proud I am that I'm handing over to such a wonderful colleague, also supported by our Deputy Director, Professor Julie Debblejack, and Sarah Caval and Paula Gerber, and the super team of Gina, Gabby, Scott, who are scattered around the place, and our wonderful academic and professional colleagues who are here supporting us today, and make all of this that looks so wonderful happen. So with all of that being said, I would now like to welcome the Dean of the Faculty of Law at Monash University, Professor Stephen Vaughan, to open the conference formally. Thank you, Stephen.
Good morning. It is very, very nice indeed to be here to see all of you. Sometimes the job of a dean is to turn up and just be delighted, and that is my job. Today, I am delighted at my colleagues. I am delighted at the work that they are doing. I am delighted at the people they are bringing together, the conversations they are shaping and enabling, at the close, careful, hard, hopeful conversation, dialogue that will come out of today. I said to Melissa, I think it was yesterday, that last year's Castan Centre conference was one of my favourite things about my first year as Dean at Monash. And so no pressure for today, but I have great hopes. Let me also begin by acknowledging that we are meeting on unceded lands. Let me acknowledge the people of the Kulin Nations as traditional owners of where we live, work and play. I pay my deepest respects to elders past and present, extend those respects to all of our First Nations guests. We had semester 2 orientation at Monash this week. There were DJs, there were people dressed up in 10-foot koala costumes, and I got to speak to our new students. And I said to them that I'm very conscious as the Dean of a law faculty, I'm very conscious as a white English Dean of a law faculty who's only been here for 18 months. I'm very conscious of the obligation on me, on us, to keep on talking about law and lawyers as vehicles of pain and oppression of First Nations peoples, but also as means and modes of hope and possibility for the future. And today, I think, is a day of hope and possibility. This is a very special gathering today. Last year, at the last conference, we celebrated 25 years of the Castan Centre, its founding in the year 2000. Today, we celebrate the 25th annual conference of the Castan Centre, 2 years of quarter-century landmarks. The Castan Centre is one of the hearts of the faculty. It plays an incredibly important role in what we do, in who we are. It transforms society through research, through education, through public debate. It is a trusted voice, I think, in the Australian and international human rights firmament. It has shaped so many lives, including so many of you who are here. I joke and I get told off for saying that Melbourne is a village, but it really is a place of very special and close community and connection. And I know how many of you have those close connections and relationships with the Castan Centre. As Melissa said, today is also a important new chapter for the centre itself. So after 5 remarkable years as director of the centre, Professor Melissa Castan has stepped down. She is now on my executive as the Associate Dean Research for the faculty. And this follows an incredibly well-deserved appointment as an inaugural Vice-Chancellor's Distinguished Professor at Monash. Congratulations, Melissa. It is very important. Melissa is so eminent. She is so well respected. She is so much a part of human rights discourse, and yet she hates being in the spotlight. So let me gently encourage you that for the whole of today, whenever you see her, do a little gentle curtsy and call her Vice-Chancellor's Distinguished Professor Castan. Melissa, your leadership has been incredibly important to the centre, carrying on your father's legacy. We are so grateful, and I think we have, I'm going to say it's a beautiful bunch of flowers. We have a beautiful bunch of flowers coming around the corner. Congratulations, Melissa. As Melissa said, we are handing the baton. There is sadly no physical baton. I was hoping for a bit of symbolism, but we don't have one. We are handing over the baton to our new director of the centre, Associate Professor Ronley Sifrus. Ronley's returning to the faculty in 8 or 9 days after a secondment to the Australian Law Reform Commission, where she was Assistant Commissioner leading the work on review of Australia's surrogacy laws. Many of you will know Ronley as an international leading voice in gender and health law and human rights. Her empirical research has been cited by the High Court of Australia, by the Supreme Court in the UK. Any of you who have ever applied for a job in the faculty will know that I have a sentence in our job adverts where I say that we are looking for people who are excellent and kind. Ronley is both of those things in equal measure. So congratulations, Ronley. We are delighted you're taking over. Another of our delights today is the wonderful speakers we have on our panels, those people with great expertise and experience getting into hard and hopeful conversations. We'll begin very shortly with a keynote address from Sue-Ann Hunter, the inaugural National Commissioner for Aboriginal and Torres Strait Islander children and young people, a Wurundjeri and Ungarai Illumarong woman. Sue-Ann is widely recognised for her transformative work in truth-telling, in trauma-informed healing, notably serving as Deputy Chair and Commissioner in Victoria's Yoorrook Justice Commission. We will today reflect also on 20 years of the Victorian Human Rights Charter. We're joined by experts at the front line of its systematic application. Dr. Farah Zamani, bringing vital regulatory perspectives from the Victorian Equal Opportunity and Human Rights Commission. I think for today, big new job starting next week. Dan Nicholson offering structural oversight from the Victorian Ombudsman's Office. CEO Caitlin Riger sharing crucial insights from the Human Rights Law Centre. We'll also be looking at international court systems, regional advocacy, welcoming the extensive judicial experience of the Honourable Lex Lasry, AMKC, the tireless and brave activism of former Hong Kong lawyer Kevin Yam, and the sharp academic analysis of Associate Professor Rebecca Ananian-Welsh from UQ. And then to anchor our day in the critical ongoing work of First Nations self-determination local legal structures, we welcome the leadership of Mariki Onus, co-chair of Gallingwall, alongside their colleagues Bridget Cowling and Carrie Walker, who will bring deep technical expertise in treaty law, complemented by the constitutional wisdom of the Honourable Kenneth Hayne, AC, KC. Let me also acknowledge our session chairs, Deputy Director and newly promoted Professor, Julie Deviljack. Reverend Julius, congratulations to you on your promotion. Julie is just returned. There we go. Thank you very much. Julie has just returned from several weeks of long service leave. That explains her tan when you see her on the panel. My great thanks to Elios Justice Director Sora Caval and to Vice Chancellor's Distinguished Professor Melissa Castan. They will skillfully, my notes tell me, they will skillfully guide our discussions today. And Melissa, as Melissa said, we sometimes forget that all of this doesn't just happen. It happens because of a lot of hard work from many of our professional colleagues, and I'm really grateful to our colleagues in the Castan Centre, in our research services team and our comms team for putting so much into today. Let me also thank each and every one of you. You are here because you care. You are here because you are interested in these hard things that we have to discuss. I'm guessing because you have hope for the future. So thank you for your time and your attention. Thank you for your presence. It is now my great pleasure to officially open the 25th Castan Centre for Human Rights Law Conference. I thought there might be balloons. The balloons will be coming. Imagine the balloons. Imagine the confetti. Again, I am delighted to be here. I think today will be a delight, and I am now delighted to hand over to our new Centre Director, Associate Professor Ronnie Sifris.
Thank you so much, Stephen, for those very kind, generous words. Good morning, everybody. My name's Ronnie Sifris. As you've already heard, I'm an Associate Professor in the Faculty of Law at Monash University and the incoming Director of the Castan Centre for Human Rights Law. Thank you, Melissa and Stephen, for your acknowledgements to country. I reiterate that acknowledgement and extend it to all First Peoples here this morning. Welcome. It is an absolute privilege to have been appointed as the next Director of the Castan Centre for Human Rights Law. It is an honour to be trusted to lead the Castan Centre and to continue its tradition of rigorous scholarship, meaningful engagement, and commitment to advancing human rights. There will be an opportunity to say more later, but I want to take this opportunity to thank Distinguished Professor Melissa Castan for her leadership as Director of the Castan Centre and for the enormous contribution that she has made to the Centre since its inception over 20 years ago. I have benefited immensely from Melissa's wisdom and mentorship and her kind and generous model of leadership. I know that many others in this room have also benefited from Melissa's time as Director. Thank you, Melissa. It is such a joy to see so many people interested and engaged in human rights here today. I would like to welcome you all to our 2026 Annual Human Rights Conference, one of my favourite days of the year. We have a very diverse agenda today, and I look forward to the many interesting and insightful discourses that will unfold. So on that note, it is my pleasure to introduce our keynote speaker, Commissioner Sue-Ann Hunter. Sue-Ann is the inaugural National Commissioner for Aboriginal and Torres Strait Islander children and young people, and a Wurundjeri and Noongar Ilararung woman. She is known for her work as Deputy Chair and Commissioner of Victoria's Yurruk Justice Commission, and is also a member of the National Centre for Reconciliation, Truth and Justice Advisory Board, an adjunct professor of global engagement at Federation University and a PhD candidate at Monash University. Sue-Ann has over 2 decades of clinical experience responding to developmental, transgenerational and community trauma. She is widely recognised for developing rights-based, transformative practice responses that empower Aboriginal people to heal from the continuing effects and processes of colonisation. Please welcome Sue-Ann Hunter to provide the keynote address.
Firstly, Vice-Chancellor Distinguished Professor Castan. Is that correct? Is that how we're doing it? Great. I was speaking to Melissa before, I think earlier this week, and I said to her, when I was younger, much younger, I said, when I grew up, I wanted to be a human rights lawyer. Anyway, got told I couldn't do that, so I ended up a social worker. But it's funny that and Melissa said, it's okay, you're, what did you say, law adjacent. I'll take that. And if I think about my social work days when I was doing, sitting in the room with particularly child protection, and there were lawyers and psychologists, and then there's little old me, social worker, I used to feel quite like you just weren't listened to. So that's why now I make sure social workers are listened to. And so I'm honoured to be here today to speak to you all. And it's always, I still can't believe when I hear that, you know, I'm the inaugural National Commissioner for Aboriginal and Torres Strait Islander children and young people, that I actually got this role. So I take it very seriously. I'm very tired. It's only been a year. There's lots of work to do, but I'm working much better after two commissions with lawyers now. You'd like to know. I think I've worked with, there's a few in the room, I won't name them, because they'll go, oh, God. So Nungodjan, thank you for having me here. Woman Jeka Bikal Waranjeri Balakul Nadanik Sue-Ann. Firstly, I wish to pay my respects to my people, the Waranjeri, peoples of the Kulin Nation, whose land we're meeting on today. I honour and recognise their continuing connection to community, to lands, waters, and I pay my respects to their elders past and present. I'd like to extend that to any First Nations people in the room today. And I also acknowledge the children and young people across Australia. They are our future. My name is Sue-Ann Hunter. I'm a Wurundjeri Narei Ilma woman and the inaugural Commissioner for Aboriginal and Torres Strait Islander children and young people. I'm getting that down pat now and know where to take a pause. So thank you for inviting me here today for this important gathering. There's a word in my language that means to come with purpose, and that word is Womanjeka. That is what I come here with today, to speak truth to transformation in recognising the rights of children and young people. For 4 years, I sat in a room not far from here and I listened. We sat with elders, we sat with survivors of missions, survivors of the stolen generations, survivors of child protection systems, survivors of the prison system, and we took their truths, and sometimes under oath. We compelled the state to give evidence, and we named what happened and what is still happening to our people. That was the Yurruk Justice Commission. Yurruk is a Wamba word meaning truth, and it was Australia's first formal truth-telling body established in Australia, in Victoria, here on my lands. I was the Deputy Chair and Commissioner. What we found was the overrepresentation of children in child protection and youth justice is not accidental. It is a direct legacy of colonisation, dispossession, and ongoing structural inequality. So on the 1st of July 2025, we tabled our final reports. Yurruk for Transformation with 100 recommendations, and Truth Be Told, the official public record. That was 1 year ago. The theme I was given for this address is from truth to transformation. And I want to be honest with you about the distance between those two words, because I'm one of the people who must answer for it. So what I want to give you this morning are 4 accounts. One is 20 years old, one is 1 year old, one is 3 weeks old, and one is 2 days old. So I want to begin by honouring the late Ron Castan, the namesake for this centre, and who I am certain come with purpose. A leading ally and advocate for Aboriginal and Torres Strait Islander people. Alongside Eddie Mabo, he fought the enduring fight for over a decade to reverse the lie of terra nullius. 10 years, 1 case, he did not ask the room for its support, he did the work. Fighting for our rights, our land, our culture, our community, our children, is sadly nothing new for our people. And the importance of leaders such as Castan and Mabo is centring human rights. That inspires my work and the work that we do at the National Commission. I mention him now because I'm going to ask you something at the end. I would like you to hold his standard against mine. That's a big ask, I know. Melissa's smiling there. As of the 1st of July, I'm proud to say we are now a statutory agency, permanent with our mandate enshrined in law. That independence gives me the authority to examine systemic issues, to conduct inquiries, to compel information, and to speak openly about what is and what is not working. I have 3 priorities, and these are nothing new: child protection, youth justice, and the social and emotional well-being, specifically the wellness, the mental wellness that sits underneath both of for our children. I want to emphasise that this role is not symbolic, it is structural. Our children's rights are inherent, and our children deserve structures that respect and protect them. The work at the Commission centres the rights of children and young people. It will enshrine law, policy and practice are aligned with the rights of Aboriginal and Torres Strait Islander children and young people, and that those rights remain the foundation for action and accountability. That is why our work draws upon international human rights frameworks, the United Nations Declaration of the Rights of Indigenous Peoples, the Convention on the Rights of the Child, and one that they didn't name specifically but is important to me. By the way, I have one of the lawyers from our centre here, and I'm not going to point her out, but I just like the way she just looked her eyes and she said, "What's she going to say now?" And that would be OPCAT. And we didn't get that name specifically, though we fought for it, but it's there in the they name as others. These human rights frameworks centre dignity, they centre safety and the rights for our children. Our approach recognises that the rights of Aboriginal and Torres Strait Islander children are holistic, intertwining social and cultural determinants of health and well-being. You cannot separate health from culture, and you cannot separate education from community, and you cannot separate child protection from well-being. All of these things are interconnected. Our laws and policies need to recognise this, and importantly, how they are applied. So the first account, 20 years of the Victorian Charter. When it comes to human rights in Victoria, the Victorian Charter is a 20-year example of drawing from international covenant and civil political rights. Section 19.2 of the Charter protects the cultural rights of Aboriginal Victorians, the right to enjoy identity and culture, to maintain kinship ties, to maintain distinctive spiritual, material and economic relationship with the land and waters. Section 17 says every child has the right to the protection that is in their best interests. Now, these are not aspirations. They have been statutory rights in this state for 20 years. And in those 20 years, more of our children have been taken from their families, not fewer. So I want to put a question to this room, and it is your question more than it is mine. What is a right worth? If a system can breach it for 20 years and nothing follows. I'm not asking rhetorically. I sat and I listened to 4 years of sworn evidence about what happened to children who held that right the whole time. The second count is Uruk's own. 100 recommendations tabled a year ago. They were not vague. They were the product of 4 years of evidence and the most extensive examination these systems have ever had in this state. A year on, the transformation of those recommendations described has not happened. That is my contested judgment. It is the position of the Commission itself, of the Federation of the Victorian Traditional Owners Corporation, and the independent legal bodies, including the Human Rights Law Centre. Caitlin, wherever you are. I want to be precise about what that means. Truth-telling did not fail. Truth-telling did exactly what it was asked to do. The truth is now on the record, and it cannot be taken back. What has not happened is the second half of the sentence, and that same pattern holds at the federal level, where these standards are not being endorsed at all, and our children are paying the price. The third account, 3 weeks ago, In January of Australia's 4th Universal Periodic Review before the UN Human Rights Council, more than 120 countries called upon the Australian federal government to better protect the rights of First Nations people and children, refugees and communities. Yet a few weeks ago, the government rejected 204 of the 332 recommendations put to it and accepted 128. That is 38%, against a global average of acceptance rate of between 73 and 76%, and down from the 51% accepted at its last review in 2021. Our federal government endorsed the UN Declaration of the Rights of Indigenous Peoples in 2009. And now 17 years on, it has declined to plan for implementing it. The result is that our kids fall through the holes in the system. Their rights to culture, family and community are taken away, and our international mechanisms for accountability are rendered powerless. The fourth account, 2 days ago. On Tuesday, the Northern Territory Legislative Assembly passed the Care and Protection of Children Legislation Amendment, Every Child Matters Bill 2026. Its centrepiece removes the Aboriginal and Torres Strait Islander child placement principle as a paramount consideration in decisions about our children. The bill passed without a single amendment, but I was asked to speak about truth, so let me put the record in front of you. The NT government commissioned its own review into Kumanjay little baby's death. It was tabled in the Northern Territory Parliament on Tuesday as well, the same day the bill was passed. The interim review found these failures were operational. Workloads, vacancies, governance delays. It made 7 draft recommendations and not one of them asked Parliament to touch the child placement principle. In a territory where 89% of the children in care are ours, that review does not contain the word Aboriginal, First Nations or Indigenous once. The bill did not come from her death. The government's own review is the evidence for that, and it is sitting on a table of that Parliament while the vote was taken. The public was given 1 week for submissions. Around 150 were received, and more than 120 of them from child and family experts, independent institutions and frontline organisations said the bill should not pass in its current form. The committee recommended it passed anyway. In a joint statement, the federal ministers and her counterparts in Victoria, New South Wales, Western Australia, South Australia, Tasmania and the ACT affirmed their commitment to the child placement principle, and that said they were concerned the bill reduces its effectiveness. The Territory Government says these reforms are evidence-based, so let's test that, because this is a room that tests claims for a living. Every major inquiry into the systems has reached the opposite conclusion. Bringing Them Home report, the Royal Commission into Protection and Detention of Children in the Northern Territory, Uruk, and if the submissions went unanswered, the claim does not survive contact with that record. And I want to name why I'm raising the Territory in a room convened about the Charter. Victoria has a Charter, and our children's overrepresentation still worsened. Queensland has a Human Rights Act, and this year passed youth justice laws in its own minister conceded were incompatible with it. The Northern Territory has neither. There was nothing to override and nothing to declare. 89% of the children in out-of-home care in the Territory are ours. Fewer than 17% of them are placed with family or kin, the lowest rate in the country. That was the jurisdiction that could least afford to weaken the principle. It is the one that did. So given my platform here today, I want to emphasise a child's right to their cultural identity, to understand who they are, where they come from and where they are going. We all have a right to culture, understanding our shared beliefs, values and customs. For our children, this must be front and centre if we are to stop making the same mistakes of the past. Which brings me to this worrying trend in public debate that is influencing our policies, particularly in child protection and youth justice. It is the framing of culture and community as being opposition to safety. The framing is wrong. Culture is not a risk factor. Bless you. Culture is a protective and stabilising, and culture is what grounds children in identity, belonging and strength. It connects our children to history, it connects them to their community, and it connects them to their future, where they know who they are and where they stand. When culture is strong, children are stronger. When community is respected, safety is strengthened, not weakened. Now, I know what some of you are thinking, but is what I am asked in every room, and I stand in. What about when the family is not safe? What about when kinship placement fails a child? Let me be direct, because I don't know any other way, because I have never dodged it and I'm not going to start in this room. Of course, some placements are unsafe. I spent more than 2 decades on the front line of child protection and youth justice. I have sat with these children. Safety is non-negotiable and no one is asking anyone to pretend otherwise. But notice what the question assumes. When one of our placement fails, we are asked whether culture was the risk. When a non-Indigenous placement fails, we call it a failure of that placement. We have never asked whether non-Indigenous families at a category are a risk factor, yet we constantly ask that about ours. The asymmetry is not evidence, it is inheritance, because there is no safe community without respect for human rights. Culture is a human right, and human rights are the foundation of the solutions that we work. Safety does not come from stripping culture away. It comes from recognising that culture is part of the solution. Truth, understanding and belonging can be transformational if we let it. And we need to listen to the truth-telling of our children. So let me tell you about one of them. Auntie Eva Jo sat with us at Yuruk, a Bunwarang Muddy Yorta Yorta woman, almost 60 years of age when she gave evidence. Her first memory is of a torch being shone in her face while she tried to sleep. The next day, she was taken, along with her sisters, her 8-month-old baby brother, and placed in a children's home in Kew. She was 5 years old. She told us, "I can't remember life before the institutions." For decades, she believed she was not wanted. And in 2018, she learned that her mother had fought to get them back. Letters had been written to her. They were never delivered. The letters existed, delivering them was nobody's job. I have carried that with me ever since. We cannot talk about a need for support of our children's rights without talking about the fact that, sadly, contact with the out-of-home care system can be a pipeline into youth justice. This is where the consequences of policies decisions become visible. It is one of the most confronting indicators of systemic failure in this country, and as any child will tell you, they do not want to be in youth justice systems. They actually fear it. Governments in this country continue to insist on locking our kids up from the age of 10, hiding the problem instead of investing in solutions. And as well as child protection and youth justice, and as Commissioner, I focus on an overall health and wellbeing. This is the best approach through early intervention and prevention, so mental wellbeing starts strong and stays strong. This is best approached through early intervention. We must invest in supporting families earlier before contact with child protection or youth justice becomes entrenched, before crisis is mistakenly becomes inevitable. Our young people tell us what they want. We just need to listen. Investing in children's rights means stable housing. It means access to healthcare. It means strong early learning. It means family support and culturally safe services that works with families rather than waiting until our families are already overwhelmed. All these things are human rights, ones that are recognised internationally and ones that should support our children here. Sadly, this doesn't always happen. There is an ongoing tension between the poor implementation of legal frameworks and the challenge of systemic barriers. For too long, policies affecting our people have been designed externally, implemented without meaningful partnership, and evaluated without community accountability. The result is systems that fail the very people they are meant to serve. When Aboriginal and Torres Strait Islander people lead policy, it is grounded in lived experience. Services are culturally informed and outcomes improve. First Nations leadership is also not new. Sovereignty and nation building have been at the heart of our existence for millennia. It has always existed in our systems of law, governance, kinship and responsibility. So what needs to change? Let's take a good example of policy, the Aboriginal and Torres Strait Islander Placement Principle, as I've mentioned. Developed in response to the legacy of child removal of stolen generation, it reflects simple but profound truth that First Nations children culture is central to safety, wellbeing and identity. And the child placement principle is often misunderstood as simply a placement guideline, but it is much more than that. It is a framework grounded in self-determination. Self-determination makes sure that no decision is made about us without us. The principle is built on 5 interconnected elements: prevention, partnership, participation, placement and connection. When fully implemented, the principle shifts the focus from crisis response to prevention, from removal to support, from control to shared decision making. It is not only about where a child is placed. It is also about who holds authority, whose knowledge is trusted, and whether systems recognise connection as a protective factor rather than an afterthought. What I'm talking about here has real consequences for our children. We have just watched the Territory do it, and Queensland is moving the same way. The weakening of the child placement principle carries a greater risk for children being separated from family, culture and community on a pathway towards permanent care. But what all the children and family experts say is that culture is a protective factor for our kids, and when permanent removal of Aboriginal and Torres Strait Islander children from their families has a lasting impact on their sense of identity, health and wellbeing outcomes. But we are not being listened to. If we are serious about change, we must rethink our approach. There's a lot of talk about protection, but what children and families really need is support. We must move away from punitive responses and towards early intervention and prevention and community-led solutions. We must invest in cultural safety that is so often overlooked in youth justice system. Cultural safety requires meaningful partnerships, shared decision-making and accountability for the outcomes. It recognises that First Nations people are best placed to determine what is safe for their children. It requires a shift in power because cultural safety cannot exist without self-determination. Without it, systems will continue to fail. Ron Castan spent 10 years on one case, so I'm not going to stand in his centre and ask you to elevate voices. Here is what I'm asking. You have a charter with cultural rights provision that have never properly been tested for our children. Section 19 is 20 years old, under litigated. Someone in this room could change that. If you practice in child protection or youth justice, the child protection placement principle is law. It is routinely argued as a preference. It is not a preference. Argue it as law. If you make policy, the recommendations Australia rejected 3 weeks ago do not disappear because Canberra said so. They are standing account of what this country owes. Keep them at the table. And if you have a platform, use it. I'm sure many of you began this work to make a difference for others. Our work aligns in that way, but alignment is not action. Because often from the perspective of my people, the Aboriginal and Torres Strait Islander people had and continue to have our own laws, our own language, our own governance systems, spiritual responsibility and deep relationships with country. Consider that we are walking 2 worlds and this is not easy. Truth-telling and treaty is a path bringing these 2 worlds together. I'm not going to go into treaty because I'll do that later. So in closing, I see a lot of hope in this room. Lots of people who care. I see you. I look at the Victorian Charter and I see an opportunity for reform, for strengthening enforcement, to make our systems more culturally informed, to work in partnerships towards structural transformation, and most importantly, to listen to our children, elevating their voices. In only a way we will understand what they need from us. Young people have told us these are things that are important to them. Community, feeling safe, feeling heard. Let's be clear, those are rights. This is what young people are asking us, to stay connected to community, to feel safe in systems around them, and to know their voices are matters in decision that shapes their lives. We must listen, we must elevate, and we must act. By this, we show our children how valued their voices truly are, and we will continue to voice our rights as First Nations people, because these rights shared across all land, sea and sky, carried through the wind of our ancestors, are inherent in all that we are and all that we do. It is foundational for identity and well-being and belonging. My responsibility as National Commissioner is to make sure our children and young people understand their rights. And it is all our responsibility to ensure that it is embedded in every decision that is made about their lives. Truth, we did that. It is on the record. It is under oath. And it cost our elders something to put it there. Transformation is the part we are still owed, because every child deserves to grow up safe, supported and connected. And I want to tell you, we cannot fail them. Thank you again for the opportunity to speak today, and Nun Gotchen.
Thank you, Sue-Ann. Oh, we're going to let people come in. Okay. First of all, we have to shame all the people that came late. So, come on. Sue-Ann, thank you very much for that. Really sobering but really powerful keynote. As you were talking, I mean, this occurs to me periodically, so I realise and then I realise again. We have enough law. We have enough human rights. We have now truth in Victoria. So it's not it's not a secret what's happening, and the situation for children is not it's not ambiguous. So it seems to me that the hurdle here is the lawmakers / politicians who are consistently negating or neglecting the real truth that's before them, and that is I mean, we're talking generation after generation, decade after decade. In your role and thinking of kind of solutions to cut through and to transform where we're at, so, you know, imagine it's 10 years down the track and we're in a different, much better place. What do we need to do with lawmakers and politicians to make them understand what you understand? How do we get there?
Okay, so it's not more inquiries, can I just say that? Because we just can't. There's just too many recommendations. Everyone's nodding. We already know, so we need to read these reports, we need to look at the evidence. It's all in, it's all there. The thing that's missing is accountability. So if you don't do something, who's held accountable? And who pays the price is the children in these systems, but there's actually no accountability for people if they don't do it. So the Northern Territory, and because it's a hot topic at the moment, is a really good example that they signed up to closing the gap and safe and supported, yet they're rolling back on their Aboriginal child and doing things in there that don't support the health and wellbeing and cultural elements for our children. But there's no accountability if you do that. There's no one holds anybody to that.
So do we have to rest on administrative litigation in order to force politicians and lawmakers and executive government to actually comply with what's already known and in law?
Look, it's a really big picture, right? And one of the things that I say to people generally is, in your own little world of whatever you do, how do you make change? Like, there's all these recommendations there that you could apply to everyday work. And I think I've sat with some people before and we've gone through your recommendations. They talk about their role and what that means. And they can make those little changes. You don't need and then if everybody starts doing that, it's just happening. And I know it sounds simple. It isn't that simple because you have to apply the recommendations to how it works. But it can be done. Just think and act differently. So it's all there. We've just got to, enforce it, 2, make it happen and integrate it into our daily work. And I think it's about being brave and bold as well. Like, we have to be. because at the end of the day, children are dying. Like, that's the reality of it. We've just been through it.
Yeah, I think for many people, this area of work is deeply uncomfortable and really challenging, and I think that people sort of say to themselves, this is terrible. I can see that it's going on and on, but I'm not the person to take this on. It's too big for me, or it's too big for our organisation, or it's too much, and I don't want to step into that space. What do you say to people who feel that this area is so tender and so difficult that they feel very worried about being in the space?
Well, I don't think it's even that. I think we all know the statistics, right? We all hear them every day, and they doesn't become children or human beings. And so when you think or see these statistics, think that there's a human life, there's a child, and you can't, how do you not act is my question. And what is the one thing you can do? You know, might be that you take on one case. I don't know what that is for you. What is it that you can do individually or your organisation can do? Even if it is you take on one case pro bono a year of a child, whatever it is, at least it's something. And in that, community starts to trust. Mm-hmm. And two, people see that you can make a difference.
Yeah.
It is tough. It is really tough. It is probably because we're dealing with children. But if we look at it, their human rights aren't being upheld, and if we don't care, who's going to?
I think we've got a few questions in the audience. You happy to take some questions from the audience? Professor Paula Gerber.
Thank you for that very insightful keynote. You talked a lot about how the law has failed, how we've had the Charter of Human Rights for 20 years and the dial hasn't shifted, or if it has, it's in the wrong direction. I think of law as one piece of the jigsaw puzzle, and another part is having the fertile ground for the laws to land and be effective. And it seems to me that societal attitudes are not keeping up with the law, that we have human rights law, we don't have a rights-respecting culture and society, particularly when it comes to First Peoples, and that was on display for all of us to see with the Voice referendum. So is there a need to try and shift societal attitudes around First Nations children and their respecting their rights, and how do we do that?
So one of the things we're sort of, I've been speaking to the Minister about this a lot, is changing the narrative of our youth particularly. And I'm not sure how we do that, but we really want to highlight there's a lot of great young entrepreneurs out there doing amazing things, and I get to meet them. So how do we highlight the good? The attitudes at the moment, like seriously, we put up a post of the flags the other day and it got 5,000 interactions, and they're all demeaning the flag. Like the flag just pissed people off for some reason. I don't know. Anyway, it went a bit viral. I was like, the flag, gee, we won't post that again. That shows you today's, society, and it's not up to just us to do that. I think, it's everybody's job, because we're not the problem. I don't know how to change societal attitudes, but what I want to do is make sure our youth are highlighted of the good work they're doing, because it's not all our youth. But if systems intervened earlier in when things aren't happening, or, it will have better outcomes. The problem is you just want to lock kids up or take them away. It doesn't help. And so I know we always bang on about early intervention, but if we don't, and I won't even say early intervention, I'll say prevention, because I think intervene invites people into your families. I think the early prevention stuff, even pre-birth, is so important, and we just don't invest enough in our children. And I sit in a lot of rooms with Deb Savaris, the National Commissioner for Children. We have to bring children, the voice of children, into the room. People don't actually generally, they'll talk, for instance, the round tables around family violence at the moment. They'll talk about the mothers or, the perpetrators, all that. And no one talks about the children. We have to actually bring them into the room. And we just think nobody cares about children. So we're in there banging on about children consistently, let alone Aboriginal and Torres Strait Islander children. They just seem to be an add-on. And so, by the way, it's not all doom and gloom. There's good stuff going on. I know, I feel like, and you know, you said this is going to be great, happy, and I've just brought it down on it. But we need to bring children into the room and youth into the room. We need to highlight the good stuff that's happening. Otherwise, I mean, I'm sure there's some young Aboriginal lawyers in the room somewhere. Like, why aren't we highlighting these people and showing, you know, people that, you know, we can do stuff? Like, who thought I'd be sitting here talking to you fellas as a commissioner? Not me, but, you know, like, we've got to highlight the good stuff. Yeah. I probably didn't even answer that very well, but...
Yeah. Charlie.
Thank you, Sue, for the incredible work that you do, and I think it's amazing that we finally have a commissioner talking about the rights of First Nations and Torres Strait First Nations children and young people. My question has two parts. The first part is I just did a big assignment on the Royal Commission into Deaths in Custody and children incarcerated in the NT, and what really shocked me was the durability aspect of, as soon as a commission comes out, we have movement forward, but then as soon as public attention shifts away, we have, you know, the age reload back down again. So I think it was less than a year they moved the age of criminal responsibility from 10 to 12, and then 11 months later back down to 10. So part of that is, how do we sort of keep, especially with changes of government, the sort of forward momentum in any of these sorts of reforms? And the second part is, do we need to have a bit of a conversation about inheritance? I think inheritance is very much thought about as like a wealth thing of, you know, money passed down from generation to generation. Do we need to talk more about inheritance of trauma and inheritance of lack of education of First Nations people? Because I think part of the narrative is like, oh, why are we still having these issues? Like, aren't we past this? But I think some people who aren't First Nations don't really understand the inherited aspect of trauma.
Yeah, they're really both really good questions. That was a lot. My little brain going here. It's too early. I'll talk about the inheritance bit only because I forgot the other question because I got stuck on that one. And then we'll go back and you can tell me what the other one is. We have to... I feel like the cultural load is on us to educate all the time, right? And I get it because we live it. But it's in everything we do. People just don't listen. It's like, you know what I'm liking it to this week? The Aboriginal Child Placement Principle. They just do it to culture, you know, and it's culture keeps the kids unsafe. That's the argument, because it'll always be the argument. And the argument is, why can't we just get over it? And, you know, and then you have politicians who come out, unnamed, by the way, who come out and say that, you know, intergenerational trauma is crap and, you know, doesn't exist. And so how do you educate people when you have such polarising opposites that people use in public forums, in their platforms, to make it a debate? I don't know how you do that, but I will always talk about the intergenerational trauma or the... I say to people, how do you remove a child? Like, think about your own family. Everybody's got a child somewhere, whether it's yours. Think about if that child was removed, how damaged that family would be, right? How can you not? And I've watched that for 30 years of practice on the front line. We should be looking at, if we have to remove them, how do we get them back home? But it shouldn't come to that, because we should do the prevention. So then we shouldn't have to be talking about intergenerational trauma. What I will say is people need to read the Bring Them Home report. That's what people need to read. And it should be in curriculum in schools, and people should understand what happened. Then they would understand intergenerational trauma. I sort of said yesterday to my team, 5 years, we've got 5 years, and there I am banging on with media about the Northern Territory. It's going to be a long 4 years left, long 4 years. But I think in my whole career with kids, nothing's changed, as in the messaging. The messaging is exactly the same. At Yuruk, there was nothing... the story is absolutely heartbreaking, and it really puts an element of humanisation on it, but there was nothing new. if that makes sense, just how it was done differently to different people and they have a different story.
And I think the other part of Charlie's question, I think, was about the sort of cyclical nature of politics and governments coming and going.
Don't.
And so
I don't even know. It just runs on a political cycle, doesn't it? And you just have to hope you get a good minister. Like, I've got a really good minister, by the way, and that's not just me sucking. Plebiscite's great. Like, I love working with her, and she's backs me in 100%. But it's unfortunately the nature of the beast. And then when you've got the cycle, and they're trying to get re-elected, who wants to bring up Aboriginal issues? Because that's not going to get you voted in. It's like I get really cynical about it. The older I get, I'm like, oh, there's an election going up. What are we going to do? We just have to keep going, and it's tiring, and we say the same things, but if we don't keep saying them, we're never going to get change. So thank you. I know that's not even hopeful. I'm trying to be hopeful. I'm here. I've got a really good job. We're going to make it.
Josh, I think there's a question out of my line of sight up in the corner. Hello, behind. Hello.
Thank you, Commissioner Hunter. You talked a little bit about what lawyers and policymakers can do to support your cause, but what can the students in the room do to also, I guess, support your cause?
I think whilst you're doing it, learn what you can do differently for First Nations children's and families. Now, I'm a social worker, so we like a bit of a love-in. And some of the best, sorry to the others, but some of the best lawyers that have worked directly with our kids have also done social work degrees. And you have this amazing, it's difficult, right? Because you've got a job to do. And I know you aren't like huggers and feelers in the room, but sometimes it's really nice to lean into that because these are human beings and people, and the law's black and white, sometimes grey. But I think understanding where particularly First Nations people are coming from, and particularly their interactions with law and where that comes from. So colonisation and how that started, and how that criminalisation was started from early on, and how that continues today. It just looks different. I would really encourage you to look at that and be human. And you can shed tears. Tears are good, all right? Lean into the discomfort.
Also, I think a lot of students don't realise the power of Aboriginal controlled organisations and the value of getting a job or an internship or a placement or a volunteer job at those organisations that are Aboriginally culturally led.
And you'll learn so much more there, right?
Yeah, it's not a book learning,
being
it's a real
within,
learning.
The organisation. So, and support us in our rallies and our, marches. And I see like faces from there as well. So I'm in a room of allies, so I can't.
I think, Julie, you had a question?
Hello, Julie Doublejack here. We will talk about charter reform for sure in the next session, but you did mention that, our children are dying because we aren't looking out for them. One, I want to say positive story, but it's not because somebody passed. A recent finding of the coroner in the passing of XY actually explicitly said there was a violation of the right to culture, a violation of children's rights in the treatment that XY received in out-of-home care, including a very articulate 15-year-old talking about why she wanted to be placed with family or kin, clearly linked to culture, that was basically just ignored by the department. That has triggered a response from the Victorian government that is about, increasing the role of Aboriginal-controlled organisations in child protection. But of course, the coroner's court can't enforce that, so it comes back to people putting political pressure on the government, and then a decision in this jurisdiction doesn't have any influence at all in the Northern Territory, where they're basically undoing.
They don't even have a child death review board anymore.
Yeah. So
how sad is that?
So some judges, for example, are receptive to these arguments, and I think we need to be making them more and more and more, because eventually some judge is going to actually pick it up and run with it. So I guess that's just a call out, really.
What's your question, please, Julie?
There is no real question, but I want to send you this decision because charter rights are actually being used. Yeah. So thank you.
Do you want to make a comment? Or we've
No,
got another,
no.
another question up there. Thanks, Julie. Just, sorry.
Hi, this is goes towards the let's think of something positive side of things, but also meaningful. What you said it'd be great to get young people in the room, kids in the room, in those decision-making rooms or in rooms where they can influence things. Can you think of some examples of that?
So obviously our legislation is very new and we're working on the policy of the privacy, and when we talk to children, protecting them and of course protecting ourselves, we're going to bring them into the room around policy. So at the moment, like there's roundtables about second action plans and what have you. I'm going to work with Deb and the Human Rights Commission. We're going to bring the children into the room to talk about those and the outcomes that people are wanting. And what I'm finding is going into the rooms with the adults is they have no idea what children want. It's really clear that they haven't actually spoken to the children. Things like bringing kids to meet the ministers directly and tell them what they want. A new policy that's being formed. I'm talking to everyone saying, invite me to everything in Canberra, everything, and eventually I'll say yes, but so there's opportunities for kids to have input into policies that affect their lives. So also going out to communities as well, seeing what they want under the 3 sort of banners that we're working on. At the moment, we've got Jumbana bringing together all the previous reports from the kids in out-of-home care and youth justice, so starting from the bringing them home report and then starting from deaths in custody. And we're going to have a bit of an analysis and really look at that, at how that can inform my next 4 years. And then we're also doing some work around what the data looks like in each state and territory. So that'll inform how we move forward. But I also want to put those plans of what we're looking at to the kids and say, are we heading in the right direction? Is this what you want? This commission shouldn't be my base. It should be theirs. So I want them in the room when we're making decisions and talking about how we're moving forward and what we're doing. And I think most of our reports are going to be lots of quotes from kids and lots of what they want. They're really excited about that too. Everyone wants to meet with me. We've got to hurry up with the privacy stuff. Anyway.
In the middle here.
I was actually coming off that same concept about bringing the children into it and that real giving them that voice. I work quite regularly with Aboriginal and Torres Strait Islander young people that are engaging in either child protection or YJ systems, and a lot of the time it feels like you're taking their story, you're taking what's happening, you're going, this is the plan, this is, the lawyers, this is the legal side, and it's kind of like they're almost a passenger in this car that is their story and their kind of space, and it can be at times quite almost personally disheartening, going, I don't actually know what I can give you that shows that you actually do have a voice and you have a position in that you're not just at the liberty of the lawyer or at the liberty of the system. Is there anything that you could share with people that are working in these spaces that is currently in existence that maybe we just need to harp on more, and maybe we just need to get to our young people and go, actually, this exists for you, to really empower some of these young people's voices coming through?
I think it's how... So I'll go back to when I was doing social work and we had, case plans and things like that. And I would sit down with them before with the agenda and say, where do you want to speak? What do you want to say? And even if the room they felt like they couldn't speak, I would be their words for them. And then we'd take a break and say, did I get that right? Giving them a voice in those rooms is so important, and how safely they want to do it. I remember a young girl, by the time she stood up in a meeting and they all were going, oh, no, don't. I said, no, let her speak. She actually said, you guys are telling me, has told me for the last 15 years of where I can live. I'm about to leave care homeless and you can't tell me where I can live now. You're just letting me go. And, that was a slow progression to get her to do that. And I was so proud of her. But really, that's her life, and you've made all these decisions about her life. And we worked really a lot on how to articulate yourself so you get heard in those spaces. And it's daunting for us as adults. How do we make it safe for them? And even just one child in a space is really important. And understanding, some kids don't even understand why they're in care. They have no idea why they were removed. No one's ever told them. Like, it's the reality of child protection. And so then a decision will get made, and they'll be moved, and they'll be, why was I moved? Or why can't I go to the same school? Or why can't I, but they end up not asking anymore because it's been done so many times. So how do we empower children? And that's part of what we're going to do at the Commission, is really get kids to understand their rights. We're going to have an education component with children, for children, that are going to help us create how we go out and teach rights to children, not just a booklet, right? Yeah.
Sarah?
No.
Oh, we'll go up to, yeah.
Thank you, Sue Ann. My name is Rachel from Monash Law. I was wondering, you were saying that there's a lot of cultural load on Aboriginal people to be educating on cultural issues, and that it's important for us to read the Bringing Them Home report and things like that to be educated. I think, to be frank, there's a lot of fear in non-Indigenous peoples, or at least a fear in me, to get involved kind of in the culturally right way or without stepping on Aboriginal people's toes and things like that. When it comes to your cause and children, Aboriginal children, how can we get involved without kind of stepping or being a white saviour in a way? Do you have any tips or ideas on that?
No, that's a really good question. A lot of people will not do because they're worried of overstepping, and if they do the wrong thing, they're worried about being called racist, or like there's a whole thing. So it actually, people just get frozen and don't do anything. I think the thing is, firstly, creating the relationship with the people you want to work with. So having a real meaningful relationship, not just, I want to work with you, or I want to take your knowledge. What can you give in return? Make it a two-way street and make it a real relationship. And I like the idea of going to, there's plenty of organisations that you could work with. I think that's, being in those moments is really important. And I just think the relationships need to be really honest and open, so that you can make mistakes and it's safe, but it's also safe for Aboriginal people on the other side. It's difficult, both sides, because I used to do lots of training in child protection, and I used to say to the child protection workers, you're standing on this side of the door going, what the hell, what am I going to get? And then you've got the Aboriginal mother on the other side of the door going, they're going to take my children, and both are in fear of doing or saying the wrong thing. And no one wants to actually open the door and go through it. So those meaningful relationships need to be had, I think, and how you position yourself in those is really important. And it's give and take. You can't just take all this cultural knowledge. What have you got to offer back as well?
Thank you very much. I think we've hit time. But thank you. And are you able to stay around for a few minutes while we're having a cup of coffee? Because there's a few people who wanted to ask you questions. But can you join me in thanking Sue Ann Hunter for a terrific talk?